Good morning, my name's Matt Dana and I'm the managing partner of Jet Probate and also the managing partner of Dana Whiting Law. And I have with me today Hallie Tessendorf. Hallie, welcome.
Hi. Thank you very much.
And Hallie, how long have you been doing probates with these firms?
The last 6 years actually I've been with you doing probate.
And how have you liked practicing in that probate area?
I think it's a unique opportunity to walk alongside people and help them through something that's stressful and difficult and maybe give peace of mind.
Yeah, I've told my wife Nancy the other day that I really enjoy this opportunity because especially, let's take a surviving spouse situation. Let's take a common husband and wife, and maybe they were married 40 or 50 years and the husband passes away. And I just had one like this in Sedona last week, and I met with the wife and just huge concerns. And how do you see that as well? And what do you see that these surviving spouses are most worried about when they lose their husband?
Yeah, I think their primary concern is, will I have enough money to pay the bills next month? Where is everything? Do I have access to it, or is it no longer mine? And so there's just a lot of fear.
Yeah, is it frozen? And there's always a lot of rumors out there that bank accounts are frozen and lock boxes are frozen, and run in there and get them out. And it's really, like you said, it's calming for us to meet with these people and give them an opportunity to let them know that everything's going to be fine. Yeah. But let's talk about representing a surviving spouse, and I'll use this example of the case I had in Sedona last week. This couple was married about 50 years, and they had maybe $1 million or $1.5 million tied up in CDs, and they had a revocable trust, and one piece of the property was in the revocable trust for sure. The other piece, they weren't quite sure whether it was in the trust or not. But let's talk about that issue. How is it that some of these people, even though they have a revocable trust, they end up in probate?
Yeah, that's a good question. We set up a lot of trusts, and then what happens is people don't actually fund, which means transfer the assets from their name into the trust. So then we'll find assets are in joint ownership, or in the trust, or in sole ownership, or beneficiary. It's just kind of all over the place.
Yeah.
So we work on trying to get people to kind of consolidate.
And this lady, it turned out that we weren't going to need a probate because, she showed me all of her bank statements, and the bank statements had both her name and her husband's name on the statements. And I told her, but even though it doesn't say on the statement, I told her more than likely those accounts had a survivorship feature where all she's going to have to do is show us a death certificate, and then those bank accounts would survivorship over to her. And she didn't believe that was going to be the case, so I actually bet her a hamburger at Mariposa that I'm going to be right and that they're going to be in survivorship and she's going to be fine. Yeah. And the next day, I told her I was going to call her, and I called her, and she goes, well, it looks like I owe you a hamburger. This case turned out to be that they were all in the trust or had the survivorship feature, so no need for probate. But let's turn the facts the other way and suppose that they not only were they not in the trust, that they didn't have a survivorship feature, and so her name was on the account, her husband's name's on the account. Talk to me about what a bank's likely to do in that scenario. Is that account going to be frozen until the husband's estate is probated, or what do you think would happen there?
It's an interesting question, because if there's not a survivorship, they each own a 50% interest in that account.
Yeah.
And she has a right to her property, and then maybe a piece of it has some kind of question. But we can kind of work to try to get her access as quickly as we can and talk with the bank if we need to.
Yeah, I think you could talk to the bank and say, hey, at least break this out. Let her pull her half out. She owns half. Let her pull her half and give her immediate access. And then let's take even the worst fear that she had. Let's suppose those CDs were only in her husband's name, her name wasn't on them, and there was no survivorship feature or there was no beneficiary form. They are just in the husband's name, and they are going to have to go through probate. So walk me through, how fast do you think under that scenario could we get her access to those bank funds?
I would say it takes some time to fill out paperwork and submit it to the court, but probably within a month to 6 weeks, we would be able to say to the bank, here, she has the authority to collect this account, make sure you move it to the estate.
Yeah, and I think that even in situations where the client's willing to do this, we can actually walk the paperwork through the court, get her appointed very quickly. And I would guess, you know, and each probate court is governed by different counties. You know, there's the Yavapai County Superior Court and Maricopa County, and they have little different rules and procedures. But I'm told by our paralegals that in most cases, especially here in Maricopa County, where you can walk these things through probate and probably have her appointed maybe in 2 weeks, right? So it's not going to be like they're frozen forever, and then hopefully there are other assets out there that she can tap into. So always concerned about that. What other situations, Hallie, can you think of where maybe it's unique where a surviving spouse is fearful of something?
Sometimes we encounter that when there's children of the deceased spouse and then herself. And so she's worried.
Stepchildren.
Yeah, stepchildren. She's worried the kids are going to kind of create a fuss, are going to be upset, angry, want their money. So we walk her through that process.
Yeah, I think that's a good one. And you know, there's a lot of tension, even though they may have had a good relationship while dad was alive or husband was alive, but there just seems to be tension and conflict created after a spouse dies, and then you have these stepchildren going against a stepmom. And that's where you hope that they have a pretty good, you know, either a will or a trust that specifies what stepchildren get, what surviving spouse gets. And that leads me to an issue. What if in that scenario where there's stepchildren that somebody dies without a will, and we're going to have to go through probate, and who's going to have priority to be the executor in that situation? Is it going to be the surviving spouse, or is it going to be the stepchildren?
So the statute kind of outlines a list, and if there's a will, we're going to prefer that. And then after that, I believe a surviving spouse is the next in line for appointment of personal representative. That doesn't change maybe how the estate will be distributed, but giving the person the authority to act as personal representative.
Yeah, I actually wrote an article, it's on the website, you know, representing surviving spouses, and talk about this tension that's created often with stepchildren. And we get this case all the time. Driving back from Yuma yesterday, called on one of these probate prospects, and it was actually, it was the stepdaughter that called in, and she was complaining and saying, well, you know, my dad died, and you know, and he only died like a few weeks ago, and that stepmom, the wife, is not disclosing the assets or not helping or not being helpful at all. And I made the comment to them that the surviving spouse really is in the driver's seat here. You understand what I'm saying? I mean, they do have the priority to be named the executor, and you know, eventually they'll get around to doing the inventory and doing these other steps. But Hallie, we really do like representing surviving spouses, don't we? Mm-hmm. They have a lot more control in these situations. Mm-hmm. Is there anything else where you think a surviving spouse is worried? I think that's a good example with the stepkids and maybe the finances. And anything else you see particularly on their minds?
Sometimes I see clients coming in and saying, well, my husband didn't have an estate plan. I guess I need to get mine sorted. And so the process too is walking them through putting together their own estate plan now that everything has changed. Yeah. And what they have is now maybe different than what they had prior. I
just think everybody should know that, you know, representing surviving spouses is a priority with our firm, and we enjoy doing it, and we want to bring that peace and comfort to them, let them know that everything's going to be fine. We're going to collect these assets. We're going to get through this. I think sometimes people worry about, well, I don't have enough money to pay the mortgage, or what, you know, what is the mortgage company going to foreclose, and all these things. But as you know, these, you know, mortgage companies and these things, they're very willing to let the probate process run its course. Mm-hmm. Yeah. Well, thanks, Hallie, for your time today. Really appreciate it.
This is a pleasure.